we'll just start with sort of what you should have in your notice of appeal. Now, we're not going to go through the rules, but it's important sometimes to just touch on some of these things. Rule 7.3, for example, requires of you, when you file your notice of appeal, to indicate what part of the judgment or order is appealed against and the particular respect in which the variation of the judgment or order is sought. And that's important because it helps, again, to focus attention as to precisely what the target of the appeal is. If we can just move on and to move to the next aspect, and that is Rule 8, and what that requires. That is in respect of what the record should contain. And it indicates as well the specific aspects that the litigants should agree upon. The rule specifically requires the parties to discuss whether the record can and should be curtailed. And that's very important from our perspective. And particular attention should be given to whether or not, for example, the appeal is likely to hinge or turn on a specific issue or fact or law. And the record should be tailored accordingly. The correspondence exchange between the litigants, between the attorneys in particular, should be included in the record because those may be important and it may have cost implications. For example, if one of the litigants, for whatever reason, is particularly recalcitrant when it comes to agreeing an abridgment of the record. And importantly, thought should be given to whether or not there should be a core bundle. Now, that is important, and often one loses sight of that. Increasingly, what's happening in our court is you have the record filed, and then in addition, you have the core bundle. Now, that just has the effect of duplicating costs unnecessarily, creating an even bigger record, because what's contained in the core bundle should actually not be included in the record, so to speak. And I know that these are matters, for example, that ordinarily should be directed at attorneys, but usually lightning strikes the highest point. And guess who's standing up before us from the bar at the SCA? And I think it's also important to remember as well that when we read these records, we don't read them as we do novels. So it's very important for there to be proper cross-referencing. So for example, I mean, when the record is being prepared, and I understand that there's usually bundles that are created for the purposes of the trial court, but often all of that is not relevant. And so documents tend to be excluded from the bundles. When a witness is testifying and is referring to a particular exhibit, it's important when we read the record to be for us to be immediately able to cross-reference that to the particular document. Now, if the cross-referencing hasn't been done, well, the record is by and large useless, certainly from our perspective.
Yeah, sorry, things are getting a little too serious, so perhaps we just lighten it up with two stories, one involving myself personally and one that I heard. So the first one was shortly after Neil Tuchten got appointed to the WLD. In fact, he was acting at the time. And we were hearing criminal appeals together. I was the presiding judge and Neil was sitting next to me. Those were the days of judges' appeals where the prisoner was brought to court and he or she would argue his or her own case. And, point in the WLD is once you've heard the appeal, you've almost got to give judgment almost immediately because there are 30 appeals on the roll for that week and you've got to get through them. For those of you who do have a criminal practice, you'll know that. So there's an interpreter and the interpreter interprets, and you know how dramatic, for those of you who speak the vernacular, you know how dramatic interpreters can be and how they sometimes juice things up. And so I was reading from a judgment and I said, as Justice so-and-so said, and I read a part of the dictum, and the interpreter said, la la la, okay? He said, now I'm going to tell you what he said. He spoke in Zulu, but I'll tell you what he said in English. He said, the judge is reading from big books, and he was intent on emphasizing big books. And he said, and he's now reading further, but I'm not going to tell you what he said because izobulala ngqondo yakho. I mean, it could be interpreted to mean let's use a little subtlety. It'll mess up your head. Okay. Second story I'm told reliably occurred, I think it was in the Eastern Cape, High Court hearing, also a criminal matter, and the judge was summing up about delivering judgment, and said, I now find myself on the horns of having regard to the facts and regard to your personal circumstances. I now find myself on the horns of a dilemma. And the interpreter looked at the judge. And the interpreter looked at the accused and said, the judge says he's now sitting on an animal I've never heard of. Okay, so at the center of an appeal always is the judgment that you're seeking to have overturned or seeking to defend, okay? Now, by and large, judges do a good job, puny judges do a good job, and apply the law very carefully, and look at it, write very nice judgments that can be defended, or at least you can understand on which basis they reasoned and can be overturned. But very often you get a lulu of a judgment, okay? I mean, a judgment, the result might be right, but the reasoning, it goes in all sorts of directions. And I think you've got to decide very early on. So the first thing is, you've got to acquaint yourself with every part of that judgment. That's the focal point of an appeal. Judgment of the court below is always the focal point of an appeal. So you've got to know every aspect of that judgment. And then you've got to make an early call. Are there parts of this judgment that just can't be defended by Sidney Kentridge, Izzy Maisels, and the Master of the Rolls all put together? Just can't defend this, okay? Or the result is correct, and you've got to find another path, and you've got to decide very early on that you're not going to stand with this reasoning. So that's an early decision to make. The other thing to do is, and there's no excuse for this, and I can't tell you what a cause of frustration it is. More recently, it's become a little more regular. When you say, now remember, we read probably around 40 to 50,000 pages a year, and that's not counting petitions. Sometimes between 12 to 15, 16,000 each recess. And so you know, very often it's very difficult to keep the cases separate in your head as a judge, talking about the perspective from the bench's side. So you're sitting there, you've read, say, in a long term, 16 cases, they're all jammed in your head, you've made notes. Sometimes like a novel, when you go through your notes, it all comes back. But sometimes it's also still a bit hazy, or one case runs into the other. So you get back to Bloemfontein, you read this. So let's take a long term. Let's take a term that is one of 6 weeks, and you would have had a 2.5-month recess before that. So this might be the first case on the roll, maybe the first case you read 2.5 months ago, okay? So you go through your record and you go through your notes, and you kind of figure you're on top of it. And then you say to counsel, I recall reading X. Do you know what page it's on? Or, or something develops in the argument. Nothing is more irritating than counsel who are not familiar with the record. It is just the pits. It is the thing that gets everybody's back up. It gets judges really frustrated because they're trying to move things along. And to get back to our patient natures, it may have something to do with the incessant pressures that you're under. Remember, you just have a certain amount of time to get through a case. You've got to manage it. Maybe a case with 4 counsel. You've got to get through it during that day. And I remember somebody saying to me about Judge Moan, who we adored in the old days, those of us who remember him, ex-Judge President Natal, and he acted for a stint in the SCA, who was met at the airport on an occasion, flying back from Bloem to Durban. And he was told that there was a case that counsel who knew the judge quite well on a personal level, couldn't understand because it was lacking in so many respects, and just couldn't understand how they got to that conclusion. And he said, and I genuinely believe this, we're as good as the counsel before us. And so it really ought to be a partnership. We don't have to be friends, we don't have to like each other, but we need to work together. And when you're asked about the record and you can't refer to the page, or you don't know what it is, or a part of the record is put to you and you can't find it at that instant, it just is incredibly annoying. So let me start there and we'll get to the law in a minute.